next case to come before us this morning is Daniel Myers versus University Hospitals Health Systems et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, let me know when we get started. I'm keeping the clock, and you can also reference it on the wall over there. Please don't use the names of any victims or minors. I don't think that's relevant necessarily to this case, but we like to make that admonishment because we are recording. It will be posted on the court's YouTube channel. The judges have read your briefs, and we're ready to see when you are.
Thank you, Ron. Good morning, Your Honor. My name is Dan Myers, and I am representing myself pro se. I'm also a consumer attorney. I'd like to reserve 2 minutes of my time for rebuttal.
Certainly.
I'm here today to ask the court to reverse the trial court's decision granting summary judgment to University Hospitals Health Systems and also denying my motion for summary judgment. The trial court's decision essentially turned Ohio consumer law on its head. So instead of having a Consumer Sales Practices Act that was liberally construed in favor of protecting consumers, it was construed in a way to create a new exemption that did not exist, to rewrite the administrative code requirements of the Ohio Attorney General's office, to create protections for hospitals that did not exist. And it was also written to eliminate what has long been the standard for consumer protection in this country and the state, which is the least sophisticated consumer standard. At the trial court level, Judge O'Brien had decided that the Consumer Sales Practices Act did not apply to this situation. She had stated that this was essentially a transaction with a physician, and that is not true. The record makes it clear that University Hospitals issued a bill. University Hospitals received payment. University Hospitals sent and performed hospital services and sent invoices related to hospital services, and those are separate from a professional bill or professional services from a physician.
So the record's going to reflect that you actually received separate billings from the physicians or the physicians' offices, the assistants that were involved here.
It reflects that it was a hospital bill invoice as opposed to the physician bill.
I understand that. What I'm asking you is, did you receive a separate invoice from the medical services, from the physician's assistants?
There was a separate bill. That's how University Hospitals does that sort of billing. Physician billing is separate from, or professional billing is separate from the hospital billing. And this dispute relates to the hospital bill in the record. The bills themselves show hospital bill.
So it was only relating to tests that were run, the urgent care room, facilities, things like that?
Yeah, whatever the services or charges that the hospital issues for that urgent care visit, as opposed to the physician assistant's time or services, or whoever read an x-ray, that those would be separate, and that this case is not about those services with physicians. There was no payment made to a physician at issue here. The lawsuit was filed against the hospital system, not a physician. The transaction here is squarely within the Consumer Sales Practices Act. It does not fall under that physician exemption that exists under the Consumer Sales Practices Act. And this court previously in the Summa Health case found that billing issues, improper billing, or whether a patient should have been billed or not for surgery-related services was a consumer transaction under the Consumer Sales Practices Act. And in that Summa Health case, which involved hysterectomy services, and I would challenge the court to think of who would have performed a hysterectomy other than a surgeon, an OB or otherwise. But that case obviously involved a physician at some point assisting in the services, yet this court still said those services, the charges for those services, there was still a consumer transaction, the Consumer Sales Practices Act applied there. The same was true for, in other districts, Thornton versus Meridia Suburban Hospital in the 8th District. That one involved their hospital services, a bill for hospital services. In Elder versus Fisher in the 1st District, that case involved a facility, like a residential facility that was charging for health care and medical services. And in the facts of that case, it even talks about physician services. And in that case, the court said, this is a consumer transaction. The hospital or the facility or the residential facility cannot claim the physician exemption because it is not a physician. And in this case, University Hospitals is not a physician. It is a hospital system, and under the binding authority from Summa Health and then what we have from these other districts, every other district that's looked at these cases, this was a consumer transaction. There's no material difference between this situation and those situations. There's always a physician involved at some level with some sort of healthcare or medical care, but that does not mean the transaction is with that physician. The second issue that I wanted to address here was the trial court's ruling that neither the receipt rule nor the services rule under the CSPA, the two administrative code requirements, apply. And that, again, is not correct. The court, in order to reach that issue, decided a few things. First, on the receipt rule issue, that's Administrative Code 1094307, and that's parts B and C of that statute or that regulation. It applies to, and that receipt requirement applies to any deposit or a deposit paid for services. In this case, I paid a deposit for services. My co-payment was the first deposit I paid of $75. After that, I made an additional partial payment of $19.62. In fact, I did that twice because I was billed for it twice. That shows that the $75 and the $19.62, those were both partial payments towards that service, towards that bill. And because it was a partial payment, by definition, it is a deposit, as the word deposit is defined in that administrative code section. So I should have received a receipt. University Hospital should be providing receipts to patients that say this amount for the first payment of $75, this amount's refundable or non-refundable, whichever the situation may be, saying what the selling price is of the service that I actually showed up for that day. And also for my subsequent payment, my $19.62 payment, I should have received a written receipt that said, you paid this payment, here's the balance remaining due. And any one of those, had they been provided, would have prevented university hospitals from overbilling. And there's no question that they overbilled me. That's been admitted. They in fact had to refund money months later because they had overbilled me. If they had just complied with that receipt requirement, we would not be here. I would not have been sent to collections. I would not have been overbilled, and this would not have been an issue. This would prevent this sort of improper overbilling, these billing issues that happen with all sorts of patients out there, not just me, not just my $75 or $19.62. That requirement under the receipt rule, there is no exemption or exclusion there from the Attorney General's office for medical services, for hospitals, for anything like that. It is simply not there. In order for the trial court to say, well, just as a blanket statement, these regulations ought not apply to hospitals, that requires a rewriting of the regulation, adding an entire exception or exclusion that simply does not exist, and the court does not have the power to do that. That's the Attorney General's responsibility and power delegated to the Attorney General under the statute, but that the court can't do that. The court can declare other things to be unfair or deceptive in violation of the Consumer Sales Practices Act, but it can't take away.
Counsel, there are quite a few instances in the trial court's decision where the trial court says you received bills that were incorrect and then did not contact the hospital. As we're talking about the receipt requirement, what if you would have went in there, given $75 as a copay, and gotten a receipt for $50?
Received a receipt that it reflected
With
the wrong one?
an incorrect receipt. Because the trial court seems to say there's indications in the statements that you got before it went to collections that they had the wrong numbers.
So if it was in the receipt when handed to me, that's noticeable. I just paid you $75, why does this say 50? Or I paid $75 and I see you gave me this receipt and it says 50, this is wrong. It's different from the way hospitals normally operate, which is you make a payment, you're not told how much the total service cost is for that. Months later you receive a bill that says you owe this much, but it doesn't reflect prior payments or when you paid it or what you paid or what it was applied to. And then months after that you receive another bill, and then maybe another month after that you receive a third bill. The way the hospital pricing works out, with it not being transparent, not being communicated to customers ahead of time, patients ahead of time, we're left in the dark and we just have to guess and either say, okay, it looks right, or no, it doesn't look right, or we have to compare months and months of statements together to see if the hospital added it up correctly. And I think that's the situation that puts too much onus on the consumer here.
But then moving into that billing, how does the hospital know what they're going to bill until they have taken a look at what's allowable through an insurance proceeds? I mean, it's usually negotiated to a different dollar figure than what they would normally. Are you just saying, I realize we're moving off the receipt requirement, are you saying, if they told me what the total cost was, no matter what it's going to become after it's submitted to my insurance, that would make a difference to me?
It here would have helped me know what the total bill was going to be, and then I would be able to add up, okay, I paid $75, I paid $19.62, I paid $19.62, and now I'm seeing a number higher than what they told me that this was going to cost me. That would be another check on that happening. I would not have personally refused services, depending on what the amount was that day, no. It wouldn't have made a difference as to whether I was going to receive services from university hospitals that day, but it would prevent confusion, frustration, multiple phone calls to university hospitals to try to get itemized statements that were not forthcoming, which is in the record. But those sorts of things would have been prevented by providing that sort of a receipt, an estimate. But the estimate itself is also kind of a step further than where we're at here. So under the services rule, which is OAC 1094305, and specifically we're looking at Part A, A1. Under the services rule, they have a requirement to provide at the first face-to-face meeting. So when I showed up at the front desk, I should have been provided with a piece of paper that said, you have the right to receive a written estimate, oral estimate, or no estimate for the service you're going to receive today, initially your choice of estimate. And I should have been provided that, and I was not. And university hospitals will admit it does not provide such a form. It never has. But that's the requirement of the Consumer Sales Practices Act. So even before we get to the issue of would I even requested an estimate that day, I was entitled to disclosure that I have the right to get an estimate, and all other patients are as well. And they're not receiving that from university hospitals. The other issue here is they do know what they're going to charge you, or at least what they charge for the services you go for. There are various federal laws, state laws that require them to have lists, so they know. They negotiate the rates in advance with insurance companies when they're in network with that insurer, as they were with mine. They know what they charge for an ordinary or average level 3 urgent care visit. They know what they charge for an x-ray. They know what they charge for an office visit. They know these things, and they can give estimates for those things. They even tell you ahead of time, if you're having a procedure, you can ask us, they don't tell you can ask us for an estimate, but they will give you an estimate if you call ahead of time. The problem is they need to tell consumers, you have the right to get these estimates, there's a form to give to the consumer. They don't do that. It's not impossible to give that form. The emergency rooms, urgent cares, wherever else, they provide plenty of forms for patients to sign and initial. It's not impossible to provide one more disclosure, giving the patient the right to know you can get this information if this is important to you, and it is very important to a lot of people.
And you're just now reaching that 2 minutes. You can continue or reserve as you see fit.
I'll continue briefly. The other issue that I wanted to touch on here, everything else covered in the briefs, I can't reach everything in 15 minutes, but the idea of this reasonable consumer standard, this is not the standard for the Ohio Consumer Sales Practices Act, outside of a few specific violations that actually refer to and incorporate that standard into the actual wording of the statute. The consumer law, according to the Ohio Supreme Court, Taylor versus First Resolution, that case they said it was the least sophisticated consumer standard. That's the traditional standard for consumer protection laws. The Ohio Consumer Sales Practices Act is no different. And the Supreme Court even noted that in that case, the consumer was able to show or demonstrate they could have claims under the Consumer Sales Practices Act under that least sophisticated consumer framework. So with that, I reserve the remainder of my time for rebuttal.
Thank you, Council.
Thank you.
May it please the court. Good morning, Your Honors. Mike Ruttinger, representing the University Hospital defendants. I appreciate Mr. Myers' passion as a consumer advocate, but this isn't the case he thought it was when he filed it. It's not a case about a hospital hiding the ball in its pricing or about intentionally overbilling patients. Discovery showed what this case is about: a front-end software error which caused Mr. Myers to receive an incorrect bill in which university hospitals fixed and refunded it upon learning of the error. Mr. Myers didn't attempt to contest any of this through discovery. He didn't notice a single deposition. Instead, he abandoned his medical privacy claim on summary judgment, and he chose not to appeal dismissal or challenge dismissal of his fraud claim on appeal. At this point, all of his eggs are in the basket of proceeding under Ohio's Consumer Sales Practices Act, even though no Ohio court has ever accepted his niche theory that a CSPA violation may be based on nothing more than an inadvertent medical billing error. To prevail on this niche theory, he has to run the table on three issues that the trial court addressed in its decision: whether the CSPA applies to the particular transaction at issue here, whether the billing error was caused by a deceptive act that would be actionable under the CSPA if it did apply, and, only if the answers to those first two questions are yes, whether he can overcome University Hospital's bona fide error defense. The trial court ruled against him on all three, and I'll address them in the same order as the trial court. I want to spend just a moment at the outset here talking about the Summa Health decision that Mr. Myers raised. University Hospitals has never contended that hospitals are exempt from the CSPA. When you look at the Summa Health decision, all it stands for is a proposition that there's not a per se defense for a hospital when it's bills than that. And in fact, what the Summa Health case did, it wasn't about a surgeon's bill, as Mr. Myers indicated. When you read the Summa Health decision, Your Honors, it was about a post-treatment agreement specific to the billing, where Summa Health agreed to provide a write-off of hysterectomy services in exchange as part of a settlement over a negligent failure to diagnose. So it was a transaction, and an affirmative transaction series of representations made specific to the bill after the fact of treatment. When we look at this case, this is not a case about a post-treatment billing dispute. It is about what occurred during the transaction at issue. The services, and the service rule and the receipt rule that Mr. Myers brought up as a basis for his CSPA claim, those are aspects of University Hospital's actions that he is saying they should have handled differently at the time he presented for treatment at the urgent care, at the point of service, not as part of a later billing transaction. And when you look at paragraph 86 of his complaint, detailing the basis for his CSPA claim, he specifically says that it is based on the purchase of urgent care services, not as part of a subsequent billing transaction. When you look at the records that were produced during discovery in this case, which are referenced by the trial court in its summary judgment decision, in which Mr. Myers never disputed, that initial transaction included physician services, including one physician who was overseeing and interpreting the x-rays that's done, and as well as a physician assistant who, as the trial court recognized, cannot operate, the word I'm looking for is care for Mr. Myers without a physician supervision during that service. So it's undisputed at this point that there were physician services involved in that November 6, 2020 transaction that forms the basis for Mr. Myers' CSPA claim.
Okay, let me ask you the same question I asked the appellant, and that is, in the record, is there indication that University Hospital sent a separate bill for the non-physician services? In other words, did the physician services, obviously we've all been involved with the healthcare system. You usually get a bill from physicians, from the radiologist, from whoever, and then the hospital itself, or the clinic itself. So what was in the record in regard to all that?
So the trial court doesn't parse this, but what comes through in the record when you look at the underlying billing statements is there are billing statements that reflect the copay, that reflect a billing for physician services, that reflect medications provided, and also testing results. It's not parsed so clearly as saying this is for the physician, this is for the services, and part of that is because it's not really possible to fully extricate them to just say this is physician services, this is the doctor's time, this is part of the treatment. because it is ultimately the underlying urgent care transaction, not any one particular bill that Mr. Myers challenges, and also how part of just as a practice how that works. You bill, in addition to the physician time, medications or tests that the physician ordered. A test that the physician ordered might be a separate bill. It doesn't mean it is separate from the physician's services, so to speak. So the accurate way of answering your question, Judge Carr, would be to say, there is a bill that is for the physician's time, but that's not the exclusive aspect of the physician's services that were received as part of this transaction.
Well, let me ask you this, because obviously, Summa Health, I have read Summa Health, and it does deal with an agreement that the hospital and the patient reach after the fact. But there are other cases that do, and that Summa even, cites to, that do say that the Consumer Sales Practices Act does apply to hospital transactions, not to physicians, but to hospital transactions. Tell me a situation where it would apply then, if everything that, seems to me that what you're arguing is that everything that a hospital does has a physician that's ordering it, so therefore kind of swallows up everything.
So the way that this comes out, and I can't recall, but some of the cases, including the Thornton case, touch on this issue, is that in all those cases, and the trial court explained it in its summary judgment decision, there is some sort of affirmative post-treatment act by the hospital system. It could involve, as one potential example, a post-physician determination to write off a portion of the charge, like Summa was. It could involve a renegotiation or resubmission of a claim with an insurer. Another example would be, and this is the example that comes through in a number of cases under Ohio law, an actual fraudulent misstatement that postdates the physician treatment about the amount that's due. And that's why, in fact, Your Honors, when you look at the cases that have allowed claims based on medical billing in Ohio, it is almost exclusively brought in the context of a fraud claim, where there's an alleged affirmative misrepresentation made after the case of treatment. What there is not in Ohio law is any case or decision that has premised liability, whether it's under the CSPA or fraud, for an inadvertent medical billing error, which is what the record fundamentally shows is the undisputed issue that's explained here. And you can see that in the trial court's consideration, both of University Hospital's discovery responses, as well as the affidavit of the Director of Revenue Services, Revenue Cycle Services, Molly Gearhart, which was attached to University Hospital's summary judgment briefing.
And I understand that argument. I guess I'm wondering, the appellant though is saying before we even get to that point, there were, requirements that the hospital should have done. And it wouldn't have gotten to the inadvertent mistake if it had followed the proper procedures to begin with.
Right, so this goes to the second aspect of the CSPA claim, right? Whether there was a deceptive or unreasonable action. So, as I said, there's nothing in the Ohio law that would allow it for inadvertent misstatement, and that's why Mr. Myers, as he has to, says, well, maybe there are other things under Ohio law that could constitute an unreasonable or deceptive practice here. We only get to those if we determine that the CSPA applies, but let's take on the estimate rule and the services rule. When you look at the estimate rule and the services rule under Ohio law, these are the same rules that apply to when you take your car into the mechanic, and the mechanic provides a written estimate in advance of saying, here's the issue, here's the work to be done. It is not possible for urgent care services to do that same analysis. At the day that Mr. Myers presents at the urgent care, university hospitals might know objectively what various services or prices can cost. It cannot, when he presents, say, here's an estimate for what is going to happen to you today. Because by the very nature of urgent care services, that's not known at that point in time. So the estimate rule at the very start is an ill fit for the notion of urgent care services. Arguably,
So, excuse me for interrupting. So it's an ill fit in this case because it was urgent care, but it wouldn't necessarily be an ill fit if it's a prearranged scheduled testing, for instance.
so the best case scenario for applying the estimate rule would be something like a prearranged x-ray or a prearranged ultrasound. There it would certainly be possible to do that. Whether Ohio law requires it is a different issue, because when we look at the specific language of the estimate rule and written services rule, First off, you can parse aspects of it and say, well, is there I believe the language is cash selling price or anticipated completion date. Even parsing those at that point is hard to do in any hospital services instance, because let's use an ultrasound for an example. You might present for an ultrasound and they may be able to tell you what an estimated cash selling price for an ultrasound would be. What they can't do is account for what they might see on that ultrasound. And what this presents in kind of the, pathway, the slippery slope, if you will, that applying estimate costs to any kind of hospital or medical services can present is what we like to refer to as the stop and estimate rule. So let's say that you find upon an ultrasound or you find upon a CT scan that there's some sort of medical issue that needs to be addressed. Under what circumstances can you stop and say, well, we now need to pause and give you an estimate. Here's what this next step will cause. Do you want us to proceed or something like that? Urgent care scenario, it's clearly not applicable. But even in non-urgent care settings, it becomes tricky. And we'd submit, Your Honors, that's exactly why the General Assembly enacted in 2017 different medical billing estimates requiring good faith estimates, not necessarily the same cash selling price estimates that are required under the administrative code provisions that Mr. Myers cites. Now, it's true that that legislation was held unconstitutional for procedural reason. I think it was by the 11th District as part of a violation of the three considerations rule in the General Assembly. But the General Assembly has acknowledged a need to provide medical estimate legislation separate from the Ohio Administrative Code provision for a reason, which is that those provisions don't fit the requirements of medical billing and analysis of medical services.
Well, I'm not sure what's in the record here. We will obviously be reviewing everything in the record. But nonetheless, hospitals we know do provide those estimates on occasion at least. And, hospitals in Ohio provide them, major hospitals.
Including university hospitals, Your Honor. In many instances they do. This case isn't about whether hospitals can provide estimates. I think we can all agree in this room, we've all had medical bills over time, and medical billing isn't always the clearest thing to follow. It is an evolving field where we see hospitals taking steps all the time, including university hospitals, to provide greater transparency and greater estimates. But whether they can do that and their efforts to do that don't necessarily mean that university hospitals or other hospital systems are required to do so under the specific administrative code provisions Mr. Myers cites, let alone that it's a violation of Ohio's Consumer Sales Practices Act for them to not do so, or for them not to automatically do so using certain forms that are being provided allegedly at the time of presenting for the services. I do want to address briefly two other revised code provisions that Mr. Myers raised in the briefs but didn't have a chance to discuss today. Revised Code Provision 1751.60 and Revised Code Provision 3923.81. He also referenced these as a basis for his claim that university hospitals was acting unreasonably. These are provisions that relate to the maximum charge that are allowable for persons under certain health insurance plans. Mr. Myers, well, first off, there's not a single Ohio case that has ever discussed either provision within the context of a CSPA case. But second, what gets lost in trying to argue that those are a basis for Mr. Myers' CSPA claim is the fact that ultimately, it's undisputed what happened here. There was a front-end software error that led to a medical billing error. It was inadvertent. That's undisputed. It was fixed. That's also undisputed. As a result, Mr. Myers doesn't have standing to argue or represent anybody under a violation of these two provisions because he fundamentally, at the end of the day, wasn't overbilled under these provisions. The last item I'd just like to address along the same lines of the undisputed record, we know what happened here. It was explained in University Hospital's discovery responses. It was explained in the affidavit of Molly Gearhart. None of this was contested by Mr. Myers. This was a software error that was fixed. There was a policy in place afterward to prevent future errors of this kind. It is a textbook application of the bona fide error defense under the CSPA, for which Mr. Myers could only recover actual damages if he was able to prove a violation. We don't believe he has. But if he was able to, and this court found that there was a deceptive practice, that bona fide error defense is undisputed and would require affirming the summary judgment decision of the lower court. which is what we asked this court to do today. Thank you very much.
Counsel, before you have a seat, can I ask you another question?
Certainly.
The trial court really emphasized in its ruling on the summary judgment the fact that the appellant could have contacted the hospital at any point in time and could have resolved this. How is that really important in our analysis?
I think it's important, Your Honors, not so much the legal application of the CSPA or whether there was a violation here. Ultimately, it is important because to the extent that this court were to consider becoming the first court that says a CSPA violation can be based on an inadvertent error, the fact that an inadvertent error could have been addressed at any time, and the record shows was addressed as soon as university hospitals learned of it, that lack of diligence in pursuing that when there were questions raised about the bills, in fact, some of the testimony that's referenced in the summary judgment decision is that Mr. Myers said, well, I don't need to follow up because I don't believe this is owed. That goes to consideration of whether or not it could be unreasonable for having an inadvertent error.
Thank you.
Thank you.
There's a little over a minute left on your.
Thank you, Your Honor. So I wanted to address that issue first, Your Honor, about the what I could have done to resolve the error. First of all, it ignores the fact that I did reach out to university hospitals earlier in 2020 requesting itemization of what was paid, what was owed, something showing I owed something. That's in the record at trial document 30 in my affidavit, to which I received nothing from university hospitals. So that's one thing. The other issue here, my theory of the case was referred to as a niche theory. It's a plain reading of the law. It's all it is. It's a plain reading of the Consumer Sales Practices Act and the Ohio Administrative Code, which is what the court is obligated to do. Intent is not required. Some sort of negligent or knowing or whatever mistake by university hospitals or error is not required. All that I must show is that they did something that would cause in the least sophisticated consumer an idea or a belief that's different than what the truth really is. Them telling me I owed more than I owed and me paying it was that's deception. It's from the eyes of was someone deceived or could someone be deceived, not what was the reason for the deception. And then finally with the Summa Health case, the Summa Health was a disagreement about whether something was included in that scope of the agreement or not. Inadvertent maybe would be a misunderstanding. But in Summa Health and with all these other cases, the courts are clear. The Consumer Sales Practices Act applies to transactions with hospitals. This was literally about something that on the top of it says hospital bill, not physician bill, like University Hospital also issues. This is a clear-cut issue where the law just needs to be applied as it's written and applied at no new exemptions created where that would have to come from the Attorney General's office. And with that, I thank the court for my time.
Thank you, Counsel. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision in due course, which the clerk of courts will mail to all parties to this appeal. We will also post it on the Ohio